Okay, it is 7:03. We'll go ahead and get started. Thank you everyone for joining us for our October For Investors by Investors Long Beach chapter meeting. If you haven't been to one of our meetings before, For Investors by Investors is a real estate education and networking club that is all about learning about what's going on in real estate investing, variety of topics, both here locally and around the country, without the sales pitch. So we're a nonprofit, no, books on tape or mentoring package or boot camps or any of that kind of stuff. We just rotate topics every month that we think might be interested to people looking to invest. This group is headquartered typically physically in Long Beach, and we normally meet at the Long Beach Public Library, the new library in the Civic Center. But of course, due to not so recent ongoing circumstances, we are still on Zoom. Looking forward to going back in person at sometime soon, but probably won't be till next year. So for the time being, convenience reigns, and welcome back from the comfort of your own living rooms. As far as a couple FIBI announcements goes, otherwise there are meetings going on at FIBI South Bay and FIBI Pasadena. FIBI Pasadena has gone back in person as well as virtual, so you can go there to the Courtyard Marriott, I believe, if you're in the Pasadena area. Also, in conjunction with Hunter Thompson and ASIM Capital, we are doing once again the Intelligent Investors Real Estate Conference in January at the West Drift Hotel in Manhattan Beach, and it's going to be in person. So we did that virtually in 2021. A lot of us, and including myself, participated in that, and it was, I think, a great conference, especially for being a virtual conference. But we're back. We're going to be back in person in January. So I think there's only a couple days left where it's cheaper to go and get your ticket and see a whole bunch of speakers. I think it's 3 or 4 days long. So that should be a great event. Hope to see you there. So without further ado, then let's talk about tonight. We've got a couple great guests. Our topic, like I mentioned at the very beginning, is landlord life in a post-eviction moratorium world here in California, with probably a heavy focus on Long Beach, since that's where this group is from. But I'm going to ask these guys as well to talk a little bit about some of the other jurisdictions around, because that's part of what's really confusing to me as an investor in multiple cities around the LA area. And so we'll just have kind of a Q&A discussion on the topic. Of course, feel free to put questions into the chat as we go along. We'll open it up for questions at the end as well. I have a few prepared to get our conversation started. And I'll introduce myself to start. So if you don't already know me, my name's Anthony Walker. I am a multifamily investment real estate broker. I'm the managing broker and CEO of a company called Buckingham Investments. We're a local brokerage company that specializes in helping people learn, plan, and invest right here in the LA area. And we do a ton in Long Beach. We're very busy in Long Beach. We've got offices in El Segundo, Torrance, and Long Beach. And I'm also an investor myself. So I'm in escrow on what will be, I think, my 17th building that I'm going to have here at the same time. Hope to close by the end of the year for tax purposes. And so I've worked with these gentlemen for many years. Bruce is my landlord attorney for any issues that I may have with my tenants. And Michael is my go-to property manager. So these guys are the right people to have on the meeting to talk to us about this topic. So let's just start with a couple introductions. Just give us a few minutes, what you do, a little bit about your business, a summary of your experience, and we'll take it from there. And Bruce, I'll start with you.
Fair enough. I've been practicing in Long Beach for the last 30 plus years. The practice has always focused on real estate. My typical client is either a property investor, property manager. They also represent a few property developers. It's everything in and around real estate. Most of my clients are entrepreneurial in spirit, so we also deal with some business issues as well as real estate transaction and litigation. Many of our clients came to know us because of the landlord-tenant work that we do, and we're very proud of the work that we do in that area. I'm blessed with a great staff who has significant experience in the area. And It's things in and around real estate. And so for a lot of our clients too, it also includes estate planning as well as more and more trust administration as time goes by.
Awesome. Thank you, Bruce. And Michael, go ahead.
Well, I'll start by saying Bruce is awesome. I think I've been working with Bruce now for probably 12 or 14 years. I don't know. It could even be longer than that. But
Since you were in high school, right?
Yeah, something like that. Thank you.
It's not even a joke, right?
Well, I don't know, Bruce. We're gonna have to talk about this. I don't know how long it's been, but I guess that's a good segue to, we're a family business. We've been in business. We celebrated 35 years this year, and we've been managing properties since the 80s, and we're currently managing 2,500 units in the Long Beach area, and some more units outside of Los Angeles County. And so we're a team of almost 50 people, and for the last 2 years it sure has been hectic. There have been so many changes. At least initially it was crazy. There was a new moratorium or a new change or a new law or a new SB. It felt like every couple of weeks, but things have settled down, and it sure is interesting. There's still some new things coming out all the time. But luckily we have Bruce on our side to help teach us and understand what the changes are. But basically, we are a full service property management company, and a lot of our clients are here on this call, and we're always happy to help anybody, even if they're not our clients. If you've got any questions, we're happy to help.
Awesome. Thanks, Michael.
Yep.
Okay, so I'm sure everyone has read that the California eviction moratorium expired. It was allowed to expire at the end of September after being extended multiple times and modified and SBs and ABs and all these things, right? And then the big question now is, okay, so is it just back to business as usual, or what's the deal if you own property and somebody didn't pay October rent? How does that work? And Bruce, maybe I'll have you start on this one since you're the legal expert in the room.
Well, first off, it's not business as usual. Frankly, remember it was a year and a half ago. Remember AB 1482?
Yep.
That was the world is coming to an end, and just cause evictions and dealing with rent caps and that sort of thing. And now that's the good old days by comparison. The rules have changed as of October the 1st. We're definitely not past eviction moratoria, whether it be the LA County ordinance, which I'm sure we'll be talking about at some point this evening, yep. Which is certainly an irritation in multiple ways, but it's not business as usual. The word of the wise is if you've got tenants that are behind in the rent, it is critically important that you participate and apply for rent relief. And the reason for that bit of information and requirement is since October the 1st, what has changed is the issuance of a summons, which is a critical element of a unlawful detainer or eviction case, isn't going to happen unless you have the ability to you'll be signing a declaration of the penalty of perjury that you have applied for rental assistance for the rents that are being demanded in the context of that eviction case, and that either the application has been denied or it's been outstanding for 20 days and the tenant has failed to participate. So what used to be a 2-page unlawful detainer or eviction complaint with cover sheets and all, we're up to about, I think it's 15 or 16 pages. A lot of them were put together quickly. They're very confusing. They're convoluted. They're poorly written. There's a lot of things that both practitioners, property managers, real estate attorneys, and the judges that we're dealing with are still grappling with a lot of the issues. There's a lot of uncertainty still out there.
Okay, so yeah, I think that gets right to the core of what the change is. And then so two things, right? It sounds like A, you've got to apply for the rental assistance, and then B, it either has to be denied, or you said outstanding for 20 days. And then does that go in conjunction with the tenant not cooperating if it's outstanding for 20? Do you have to just wait until we hear, or are you able to start your eviction proceedings at that point?
Well, technically, you have the right to file the eviction lawsuit. but you're not going to get a summons issued. And that's one of the procedural issues or logistical issues, probably a better term, that hasn't been resolved yet. I have a significant concern that if a client should choose to, file their case so they can get the complaint on file, and then wait for the time to run and then try to go back to court and dealing with the clerk's office that has not responded particularly well over the last couple of years and all the changes they've gone through. I'm not sure that logistically is going to be an appropriate path. Our general recommendation is to get past that hurdle of the outstanding application having been outright denied. But one concern we do have is there's kind of a middle ground. I think Mike will be able to comment on this better than I. And that is, you can apply, and what level of participation that's required of the tenant is not clear. I'm getting feedback from some of my property management clients that they are saying, hey, if they log in once, then it is showing as in process. And that could delay the process, frankly, somewhat indefinitely. And we're also having issues with just delays in everything associated with the process, including the sheriff's office is now backlogged because they're short-staffed as well.
Wow. So then that begs the question, and this one's probably for Michael, what are we seeing on those relief fund applications? How long is it taking to get a response? And what are you seeing there?
Well, we've got about 400 relief fund applications outstanding. And I would say that we've probably received funds on, I think the last count was about 100 of them or 120 of them. And the city of Long Beach is probably, is definitely the slowest city. They're administering their own funds. Whereas a lot of other cities and counties are either allowing the state to do it. Housing is Key is one of the websites. I think that's a state direct, or
right.
Counties are administering it. And frankly, the city of Long Beach has been the worst group to deal with in terms of getting the funds. So I would say that probably 2/3 of our applications are still outstanding. And my understanding is that they're first going through the period of March 2020 through October. Then they're going the period October to October, and then they're going to look at applications for October of this year through I believe it's all the way through March. So people can still apply for funds for current months all the way through to March. And so basically Long Beach is very slow. We have started out of the 260 or so residents that we have with over $1,000 balance. We've only been able to start 4 evictions because most of the folks that owed money prior to October, they declared that they have been financially impacted by COVID. They paid 25% of their rent. And they're protected for that period. We're going to start another probably 11 evictions. Bruce, get ready, either tomorrow or early next week. And those are folks that have not paid October rent. We gave them a 3-day notice, and we've applied for funds for them. Right, so that's the first thing we do is fill out an application for them when we send them a 3-day notice. And then if they have not made any, if they had not done anything on their part in terms of logging in or delivering documents that they need to deliver to the program, then we evict because they haven't done their part.
So you mentioned a lot of stuff there that deserves a little bit of follow-up. So first of all, kind of the main thing that ended about the eviction moratorium was that 25% rule, right? So we get a lot of questions from people that, the rule during the California moratorium, at least, was that if the tenant claims COVID hardship and they make 25% of the contract rent payments, they're protected from eviction. So that's no longer the case, right? They owe the rent starting October 1st. Is that right?
Correct. Yeah, and Bruce is going to have to answer this one. I believe that even if they didn't pay 25% of the rent, then and they're applying and attempting to get funds, then they're also protected. But Bruce, you're going to have to clarify that. But sorry. Well, we'll get back to it. But in terms of October, yes, we can evict based on a 3-day notice. for October's unpaid rent, and only October's unpaid rent, because there's no protection for financial impact or 25%, none of that.
Right.
But we still have to apply for funds and wait the 20 days.
Right. Okay. That's what I was getting at right there, is I think that's the key difference. The moratorium's over, but there's still eviction protections. But you said something else that's interesting. It was a 15-day notice previously, right? And now it's back to 3?
That's correct.
Okay. Interesting.
One thing to make a point, though, is while we're using a term that we're familiar with, 3-day notice to pay rent or quit, it's not the old school 3-day notice that we're accustomed to. There is akin and very similar to the 15-day notices, which required you to identify the due date and the balance owed on a month-by-month basis. That is still the case for the 3-day notices as well. And just a reminder for all that it's a 3 court day response period as far as the opportunity to perform, as opposed to the old school, which has been that way for a while now, but some of our clients still forget.
Got it.
And Bruce, my question was, because somebody actually asked me that today, if somebody did not pay 25% during the COVID period, we still can't evict, right? We still have to apply for funds.
You have to, any funds that you are pursuing in the context of the lawful detainer action in which you're engaged, you must be applying for those funds. And one of the killers as well is you may think, okay, I got my 20 days in, or they've been, and they haven't participated, I can start the process. The tenant will have the opportunity anytime prior to actually being removed from the property, if the ship comes in and they find the money, then you are going to be required to accept the funds. One thing that is not clear, but I think I know what the answer is going to be. It's not identified anywhere that you're made whole in the context of the expenses associated with the unlawful detainer action. So you may end up inspiring your tenants to participate in the program if they haven't before, and you may end up with a net economic benefit, but it won't be without its expense.
So interesting. So that brings up some questions for me too. I'm again coming back to that 25% rule, right? I guess from what I can recall, if the tenant followed the rules and they paid the 25%, then the rest of the 75% has been moved to consumer debt and can't be used for an unlawful detainer action. Is that where we are now?
I'm going to nitpick just a little bit.
Okay.
The only thing that requires the conversion of that 75% is going to be the signing and delivery of that COVID declaration. It is not further conditioned upon the payment of the 25%. So the 25%, the balance due on the 25%, you are entitled to pursue that. And it's a little bit goofy the way the documents are set up, but it appears as though we're going to be able, in the context of, so long as you have applied for the previous months. A lot of our clients in September did kind of a cleanup notice where they went ahead and brought themselves current on any notices any periods which had not had notices served. They'd go ahead and do that, because part of the process now is you are required to identify how much money was owed during the September of last year, September 1 of 2020 through September 30 of this year, and how much was paid. So there's actually going to be an opportunity, it appears, because the code's not clear, that you may be able to recover the balance on that 25% in the context of the current cases.
Interesting. Very confusing.
It's incredibly confusing. And one of the biggest confusions is, and that's why the record keeping and how you're dealing with the application of rental payments is critical. You want to make sure that you are, if you have a tenant who gives you any instruction as to how to apply the payment, you're required to follow that. You can't use the old school or apply it to the most past due. You're also required, if it's tendered in a given month and there's monies that are owed for that month, you are in a position where you apply it to that month, regardless of whether they've had a past due balance prior to that.
Interesting. So Michael, that then brings up a good question that I've been getting a lot of. you would think that maybe there's a handful of tenants that took this time to not pay the rent and establish some savings and now start paying the rent starting October 1st. It's been almost the whole month of October. Did you see a lot of that? Did a lot of tenants that were not paying suddenly start paying the October contract rent?
Well, I knew you were going to ask this question. So we had, I'm going to give you two facts that I found today, some data that I found today when I was looking that up. At the end of September, we had 260 tenants owing over $1,000, so about 10% of our portfolio. Today we have 230 tenants owing over $1,000. So that was my first sort of inkling that was true. So what I went and did is I compared the delinquency at the end of last month, the delinquency today, and I found that 30 people dropped off and another 100 have made substantial payments. It doesn't mean that they've paid everything. It doesn't even mean that they've paid this month's rent. But for half of the people who owed a substantial amount of money in September to have made a large payment, and I cut it off at about $600, right? So sometimes even half of a rent. We are receiving more money. The overall payables are coming down. Receivables. And what I expect to see is I expect that number to continue coming down, and for most people to get back on track, especially when they get funds from SB 91 and the city of Long Beach. But I expect that all the folks that are waiting for money from the city of Long Beach to continue to rack up the rent charges until they'll pay through, which I think is going to be March. And as long as those people keep on attempting to check in, then they're going to be protected. The good news is I think that we're eventually going to get those funds. We've had some people decline, but generally the only people that have been declined is because there have been duplicate applications made, one by the resident, one by us, the manager. We haven't seen almost any people be declined because of too much income, making over 80% of the median household income, or any other reason, frankly. So it's very slow, very inefficient, but I think we're going to get most of the funds that are due. I mean, in fact, we're seeing money come in from people that have already moved out, and that's positive too. It's not even on, it's not even on the books anymore in terms of past due rent, but we're still receiving checks on behalf of those moved out residents.
Definitely a positive sign. It sounds like the word is out. So then on October 1st, did you end up issuing a whole bunch of 3-day notices, or what happened on the day this turned over?
Absolutely. I asked the number, but I didn't get the answer. But if I had to guess, we probably issued a few hundred 3-day notices. And I think that people were surprised to see 3-day notices instead of 15-day notices. And that could have been the impetus for a lot of these rent payments. But like I said, they're only resulting in probably about 11 evictions right now, because primarily because people who we've applied for, right? We fill out the application at the same time we give them a 3-day notice. They're doing their part. And so in the end, that's going to be good. And the 11 folks or the 15 people that we have in eviction right now, those are the funds that we may never be able to recover, or as I just mentioned, maybe after they're evicted, will eventually get paid. But those are going to be the main, large balances that are going to go through all the way through to the end of eviction, which who knows how long that's going to be. I'm curious. I don't know if Bruce has any idea, but if they used to take 2 or 3 months, I'm guessing they're going to be 4 or 5 or 6, from here on out.
What do you think?
We don't know. I mean, it's the bottom line. But the reality is, the courts have, in fact, responded, anticipating in a positive way, in that when it comes, what's happening more and more is they are, in fact, taking judges and assigning them to unlawful detainer courtrooms just for trials. As an example, the judge that we had for a long time in Long Beach was reassigned to downtown Los Angeles. And he went from being a small claims court, unlawful detainer judge, and had other responsibilities as well. He is 100% unlawful detainer trial courtroom. So he's handling the overflow from other courtrooms. The judge that we have in Inglewood is being reassigned to Torrance to do the same thing. So they are making some efforts to make courtrooms available. We're still having challenges with unlawful with jury trials and the availability and willingness of jurors to participate in the process. They're still trying to practice social distancing in the context of the jury pool. One of the options is to reduce the number of jurors that's required. That's something that most defense counsel will not stipulate to. The result being that we're still seeing a backlog in the jury trial process, and that's in LA County as well as Orange County.
Wow. So thinking through this new 3-day notice again and the rules, are there disclosure requirements? Do you have to, along with your 3-day notice, explain to the tenant that you need to apply for relief funds, and if you do, then you won't be evicted?
There are statutorily required, specifically required information in that 3-day notice. And frankly, I haven't read it for a while because it just wasn't relevant. I'm not sure what it says, but I know that it's important that it be exactly as it's required by the code.
Interesting. Wow, what a mess. So for a tenant who's not paying rent, the best options, right, are just basically help them apply and then wait is kind of the answer. And if they really don't cooperate, those are the few isolated situations where you're going to end up in an eviction.
Correct. And one of the things that I was talking to another property management company client of ours that has processed a lot of applications. And Michael, be interested in your feedback on this as well. She has found that some of the tenants that she is dealing with, frankly, just don't know how to navigate the process.
Right.
Or they're so intimidated by the thought of getting into it, they don't even make the effort. So what they have been doing is they have actually been saying, we're happy to help you. Come on down to the office, bring your paperwork. I'm not going to sign your name and do stuff like that for you. But if you need technical assistance, or they just don't have access to a computer, or whatever the issue might be, they are finding that some of their tenants are coming in. And Michael, have you been doing anything like that?
Well, our supervisors go to their doors. I mean, we won't start an eviction without making direct visits to the property and knocking on the door and trying to have a conversation with them. Generally speaking, the folks that we're evicting, I don't believe it's because they don't know how or don't have the ability to. But we are doing the same thing. We're communicating with them. We're offering to help. I haven't offered for them to come down to the office. That's an interesting one that I might, give that information to my team tomorrow. But generally, the people that we're evicting are folks that are just, obstinate and fighting us, fighting the system, and they see that there's really no benefit. It's going to take probably 6 months to evict them anyways. They could probably have the record sealed. I wouldn't be surprised if they were allowed to have the record sealed. And who knows, at some point, maybe they can apply and get that money paid to the landlord anyways. But just mostly incommunicado and not responding is the issue we're having with the folks we're going all the way to eviction with.
Got it.
One passing comment, Michael just said something that triggered it. One of the rules that is still in place, that you cannot assign or sell your debt that is associated with rent. There are specific prohibitions against that. So that doesn't mean you can't engage the services of your attorney or a collection company or whatever to pursue enforcement of items on your behalf. And of course, the small claims process will be opening up here fairly soon, so that you can pursue that civil consumer debt, that 75% that was converted. And that, I think, is going to be an area where there is going to be a significant increase in activity.
Interesting. So I've heard of a lot of transactions going on where, a buyer attempts to ask a seller to assign that debt over. And so that's not allowed. I didn't know that.
Well, you can, I would be careful under those circumstances. It depends upon how it's approached. I don't know whether just the outright assignment is I'd have to look at the code. A sale of the debt is most definitely not permitted.
Got it. Interesting.
Anthony, I wanted to make a point too about the small claims. I've got a lot of clients asking me, are you going to help me take my tenants to small claims court? And I'm looking at this list of whatever 300 people, and I probably don't have the resources to do that. I wonder if there are going to be companies coming out of the woodwork that'll help you with that, not attorneys, right? Because you can't have an attorney. But what I think is probably going to be a better route for us. I mean, unless it's $20,000 or $30,000, and that's rare. It's more like $5,000 or $6,000 or $8,000 or something like that. What I'm going to recommend to my clients is that they allow me to go and try and negotiate that. Because if I go to small claims court and I get a judgment for $8,000 and I send it to a debt collection company that's going to charge 40% and probably never get anything, I think I'd be better off to negotiate a deal with that resident to pay $4,000 in a payment plan over the next 18 months of whatever, $200 a month. And so that's going to be what I'm going to try first, because I think it's going to be more effective. Some people really did have a hard time. Some people really do need the help. And I'd like to think that that's the case of most of the residents that are going to be owing money. And we're going to try that first. After that, of course, we do have to go the legal route, and I've got to figure out how we're going to make that happen. But that's going to be my first step in terms of before small claims.
I think that would be more effective too.
By the way, another trick that a couple of my clients over the years have used with some success is they'll actually prepare the small claims paperwork, but they won't actually file it or serve it. But they will basically send the letter of, enclosed herewith is a copy of the prepared but not yet filed small claims action. Basically, the train's coming down the path. And they have had some success with that approach.
Yeah, that might be a good way to start the conversation.
I think Michael's approach is probably have the conversation first, and maybe
here's step two.
If they're not,
right?
yeah, this is step two. I think I would agree with Michael, but I don't think that's the first volley. That's a follow up to get them to answer the door, or maybe answer the phone.
Right. Yeah, because that's often what's not happening at all, right? Interesting. Okay. So we talked about, most of the conversation so far has been about like the changes in the state rules and the expiration of the eviction moratorium at the state level. So let's talk a little bit about some of the differences in jurisdictions. So we have the state level, we have the federal level, which from my understanding is also over. And then what's probably more primary in a lot of people's minds here is we have LA County, which has a different set of rules. And then you have Los Angeles City, which is huge and covers more areas that seem like they might be cities, but are actually part of LA that people might own properties in too. So can we talk a little bit, maybe Bruce, start with you on the differences with LA County and then LA City, what the rules are right now?
Well, the LA City is pretty much the same as it has been. It's going to continue on. You can't charge late fees. You can't, there's still restrictions on dealing with the eviction process at all. To your comment about areas that people aren't necessarily aware are part of, subject to LA City rent control. San Pedro is kind of one of the notable exceptions. A lot of people aren't familiar with San Pedro and other such areas. It's kind of the strip from downtown Los Angeles all the way to the port is where you potentially have to deal with those issues. The LA County is probably the more troubling, and most people that are in Los Angeles, they are plugged into the system. They've been dealing with rent control for a while. They're used to playing the game and following the rules. It's the LA County moratorium, which, by the way, they changed the name to tenant protections, thinking that was just more appropriate. It has been extended. It has been extended and somewhat refined, but it's been extended through January. One of the big open and not fully answered questions is whether the county even has the authority to issue this ordinance. They certainly have the authority. They've always had the authority to deal with unincorporated parts of Los Angeles County. So if you're in an unincorporated city like Long Beach, everybody for decades has known the LA County can't do anything with you because that's not their territory. The LA County ordinance specifically says that it is does attach and does have effect in incorporated cities. We've had a couple of cases in which we have thus far unsuccessfully argued that the LA County ordinance is not enforceable within incorporated cities. The experience of other attorneys that I deal with has been the same. The most recently case about 2 weeks ago also went down in flames from the landlord's perspective, with the judge not having the backbone to pull the trigger and say that LA County has overstepped their bounds. That case right now is being appealed. So the LA County ordinance, as a lot of the ordinances that are more local, have substantial, very heavy-handed financial consequences for, I'm going to use the term, harassment is the word they use. And they use, and harassment as defined by the statute or the ordinance is just about anything. I mean, serving a notice without a good faith belief that you've got the legal right to do it, continuing to communicate with your tenant after they've told you about their past due payment of rent, after they in writing have told you they don't want to talk to you about it. And the fines are from $1,000 to $5,000 per day. So the LA County ordinance, and frankly, the LA County Board of Supervisors, it's just out of control. And that's probably the more troublesome one, because it basically prohibits no-fault evictions. I have a case I'm dealing with right now where my client, in my view, legally, we served a notice to quit because the property was in escrow. There's a specific code section that gives some flexibility for owners that are in escrow. And the opposition that we're encountering, and the motion we'll be arguing next week, is the applicability of the LA County ordinance to our situation. We're dealing with two issues: whether the county has the authority in the first place, and secondarily, whether they have the authority in this specific instance involving the escrow related situation. There's so much uncertainty right now. That's the hardest part.
So are the rules different then at the county level than what we just spoke about at the state? Are evictions just plain out, you can't start an unlawful detainer action, or is it the same where if they've applied for rent relief funds or if they don't cooperate, then you can do it?
Well, in fact, I guess the overarching comment that's appropriately made here is the way that the ordinances and the laws are basically structured. Whichever one is more protective of the tenant, or from another perspective, more abusive of the landlord,
right.
That's the rule that applies. So you still have the ability to pursue at-fault evictions with some limitations. You can certainly pursue non-payment of rent. That's clearly available. But in LA County as well as LA City, some of the provisions that you used to be able to enforce, like anti-assignment and subletting, unauthorized occupants, there are codes, the sections of both LA City and the LA County ordinance, which specifically say you cannot evict if it's an expanding household, including the addition of animals, if it's COVID related. Of course, how are you going to prove that your expanding household is because of adding a dog is related to COVID? The reality is, all they have to do is say that it is.
Right.
That's kind of one of the other foundations. Whatever the tenant has very little exposure. And by the way, one of the significant components of the ordinances, both in the county and LA City, is that, and frankly at the state, there is a civil right of action, basically to pursue a perjury claim. So tenants with impunity can go ahead and merely sign a declaration, not providing documentation, and not have any negative consequences for that. But there are specifically stated consequences where either the party involved or someone with an interest, so it doesn't even have to be a party that's related to the case, has the ability to put a private right of action to pursue a civil claim for perjury.
Wow, that's wild. So we have a good question here on this topic from Alex. In the unincorporated county area, the mandatory annual reporting of rental properties. He just received this for a condo that he manages in the county strip. Is that really a thing? Are we going to have to do this for all rentals going forward?
That is a trend that has been bantered about at every level of government, including the state.
Right.
Thus far, for the most part, that hasn't happened. But just like in Los Angeles City, where if you want to do a cash for keys agreement, you have certain hoops you need to jump through, rights to terminate or rescind for 30 days, required disclosures. That's also a government database keeping track of how much people are getting paid to move out. And I think that's a growing trend. And yeah, it is for real in LA County.
Wow.
Unincorporated as well. The unincorporated has I think it was March of 2020, right as COVID was starting. There was a stricter form of rent control that applied to unincorporated LA that didn't before. And I found this out because that summer I bought a property in Whittier that was an unincorporated area, and the statute said that that there was a particular amount that I had to pay the residents in cash for keys to leave. And that document is not being released until next month or something like that. And we were supposed to register these properties a year ago, and they said they would open the website, but the website never opened. So basically, this has been 18 months in the making. And finally, maybe they're getting. I got those same letters that you got, Alex.
Wow, that's wild. So, Bruce, what I'm trying to establish is like what, at least on the case of non-payment of rent, because it sounds like it's so complicated with all these other matters depending on your jurisdiction. I'm trying to figure out what landlord rights are for non-payment of rent. So I've heard that LA City is still just blanket moratorium for any eviction at all, even non-payment of rent. Is that the case, or am I wrong on that?
It's not on all evictions, but generally speaking, yeah, LA City, you're just hosed.
Wow. And no even requirement for the tenant to have to apply for rent relief funds?
No obligations of any sort that I'm aware of.
Wow. That's the scariest one to me, right? Is, hey, at least if you have to apply for the rent relief funds and you have to wait, at least you'll get the money. But I know there are some owners that have tenants that just refuse to open the door and do nothing. They don't have to, apparently.
Which makes no sense. I mean, like Michael made the comment earlier that you have some tenants who I think somehow think they're sticking it to the man by, depriving a free source of funds to pay their rent for which they're financially obligated. So the thought process is certainly nonsensical.
I don't get it. And Michael, is it not possible, I suppose, for the landlord to apply for the relief funds themselves without the tenant's cooperation?
Well, that's correct. We'll still apply, but the tenant has to cooperate. The tenant has to show proof of income to prove that they were that they're less than 80% of median household income, as well as they need to provide I think utility bills and say that they've been financially impacted by COVID. So, it was one of the things that we were hoping from AB, I think it's 1132 or 1182. We were hoping that was going to require or allow landlords to apply on behalf of the residents without the residents participating. But that is, they must still participate.
That's just crazy to me. Yeah, I mean, it's one thing if you let it happen, but just insane. And then another question here about how about no fault evictions for City of LA? Can these move forward in any reasonable way? Say like a buyer wants to own or occupy a unit or renovate and get permits or take it off the rental market. Ellis Act evictions, are those all currently off the table?
Ellis Act is definitely off the table. Removal from the market is off the table. The LA, I believe it's also off the table for owner occupancy. I'm not sure on that for LA. I am sure what LA County did is, from their perspective, they expanded the owner occupancy or family member occupancy standards. But where it's ridiculous is one of the key requirements of the LA County ordinance for owner family occupancy is that the incoming occupant has to be equally or worse off financially than the tenant. It's no longer enough that they aren't related to the owner. And there's also a provision in that if you have a tenant who is age 62 or older, you have to have your incoming family member also be 62 years of age or older.
Oh my God.
I mean, the complexity across the board is just, they have the illusion of, we're with the government and we're here to help. It's all hocus pocus.
So you're telling me if you do accelerated cost segregation studies on your properties and make zero money, then you're lower income than your tenants, you might have a chance.
And what's interesting about that, I had a client, and this is really a sad story, that many years ago, she and her husband found themselves in a very difficult situation, very much as a mom and pop. They had both lost their jobs. She needed to apply for food stamps. And because she owned real estate, she didn't qualify.
Jeez. Crazy. So really cash for keys is the best option or the only option.
But what I can also tell you though, I talked to a particular defense attorney who used to do a lot of cash for keys agreements. And he was typically able to convince his clients to move out for $3,000, $5,000, $7,000. And now he's complaining that his clients are crazy. They want $10,000, $15,000, and $20,000.
Right.
The price has gone up for sure.
I know that's the case in LA City for sure. Michael, I know you've been doing some of that in Long Beach. Is that staying about where it's been, or is that rising?
No, I mean, I think it's rising a little bit, but not. I don't see 10 or 15 or $20,000. But it also depends on where the rent is compared with market. I mean, that's the real the real piece that is critical. If you're at 50% of market, it's going to take a lot more than if you're at 75% of market. And chances are, if that unit's at 75% of market, it's probably not upgraded or very mildly upgraded. So you're closer to the market for that unit, right? So in that, 60 to 75% or 60 to 80% range, usually you can get people to go for $3,000 to $5,000. We haven't done a lot of cash for keys deals for much more than that, primarily because we're trying to get funds from the city of from Long Beach or from whatever city we're working in to pay the rent. Now, if there are folks that are buying properties and they're trying to turn over units, I have a client who's trying to do cash for keys in a building that has 10 units, and those are probably at about, 60, 65% of market. And he's having a really hard time, and he's having to go up and up on price. And he decided to just sit back for a little bit because he's concerned that those residents are going to potentially create issues for him or call the news. It's happened before.
Right.
Or even complain because Long Beach has its own anti-harassment ordinance that he would probably be subject to. So anyhow, I do see the price going up a little bit, but I don't see it drastically higher than it was like what Bruce has seen. But I don't know what neighborhood he's in, Bruce. And like I said, we're not doing as many cash for keys as we were a couple of years ago, just because most of the cash for keys that we did were to try to get people to pay up or leave. And right now we've got somebody paying up for them.
Wow. So there's a good follow-up question here from Paul. Is there any risk where you have a cash for keys agreement and then later the tenant comes back and comes after you for taking advantage of them if it's too little or something like that?
Well, there's going to have to be more than just, I didn't get enough money out of the deal. I mean, or how can you pay my neighbor more? That's not going to be enough. It would have to be something more along the lines of some sort of fraud in the inducement to the other angle that I would conceive of being played would be anything from claims of threatened to turning them into immigration, or to do something, or to make threats of legal action that wasn't otherwise available, or something along those lines that it improperly inspired them to sign the agreement. But that,
Got it.
other than that, it's going to be a bit tough. But don't forget, I mean, if you have a situation where there's an attempt to rescind that type of a contract, depending upon the numbers involved, it may be cheaper to rescind the deal than fight against this. It's going to be a function of how much resistance you're going to encounter. And like Michael mentioned, do you want to be that guy that's the lead story on the news?
Right. Got to be careful. So Alex, then Michael has a good question on just the mechanics of the cash for keys agreement. I assume you don't give the money until you've changed the locks and they've turned in their keys, right?
No, yeah, we meet them there generally with a check and exchange the keys for the check. So definitely not give them money up front. I've seen situations where you give them a little bit of money up front because they need to get a moving truck.
Right.
But then you're still holding, 3/4 of it or whatever until they give you the keys.
You do your standard move out inspection and all that.
Sure, and sometimes we're doing that move out inspection before we do the cash for keys agreement, right? If I know that their unit is in pretty darn good shape, then I'm probably not going to process a move out, and the deposit is going to be part of the cash for keys agreement.
Right.
And plus we're meeting them there, so we're able to see whether it's, they've taken a hammer and put holes all over the place. But I've never seen that happen. They have no incentive. They want the check that's in our hand.
Got it. So I see Ray's question, and before we get into the complexity of that specific situation, let me ask about another popular topic here, which is the substantial renovation term in AB 1482. I know that Long Beach currently has a moratorium on evictions or vacating tenancies for substantial renovations. Obviously in LA, all no-fault evictions are banned. But what about, if you happen to be in another city that is incorporated, and are you able to do that? Is that legal currently, or what's the process?
Michael, is he asking you, right?
Oh, I think he's asking the legal expert. Well, I'll tell you, in Long Beach, of course, as you said, there's a moratorium, and I think they'll probably extend that indefinitely, and come up with a new statute to extend that. In terms of other cities, most of my clients are buying their big value adds in the Long Beach area. So I haven't attempted to do any other evictions for substantial improvement. In Long Beach, we were getting ready to do a few when COVID hit. And,
right.
And so I don't know. I think in other cities, probably you could, but Bruce could answer that better than I could.
Well, generally speaking, you're right. The state law still permits it. But the problem you've got is, if we're talking about LA County, you've got that overarching issue of, do you want to be the test case to make the argument that the LA County ordinance doesn't apply? Because it most certainly does apply to even the substantial rehab process.
So you could end up in appeals fighting the battle to prove it, that it should be okay. Although on the other hand, your tenants, I suppose, could just agree and move if you give them that notice.
Sure. And one of the comments that Michael made about paying for a moving truck and that sort of thing, one of the components that's been in the LA city rent control for forever, as far as I know, is that you have the ability to actually set up an escrow account, and an attorney-client trust fund can be utilized as that escrow account, so that funds can be deposited in advance and then dispersed directly to, in the case of the paying for a security deposit, to making the payment to the new landlord, or making the payment directly for the storage or for the moving expenses, so that you have some better handle on making sure that the money is going where it's going to facilitate the relocation.
Right, that makes sense. And so maybe Bruce, you may not work in the Inland Empire, but Ray's got a question about a specific situation, which I think would be interesting to consider from a city that maybe doesn't have its own, brand on the substantial renovation either. But if he's got a tenant who owes a few months rent, is it possible to do a substantial renovation eviction there, or is really cash for keys the best approach?
Well, first off, every case is city dependent. So you've got to check to see if there's even a prohibition at the city level. Generally speaking, the further east and further you get away from Los Angeles, the more flexible and more landlord friendly the rules are. Interesting story in Riverside. An attorney that used to work for me actually is working with Riverside Legal Aid, and they actually have a pretty large pool of money available to facilitate tenant rent payments. So there are resources that are beyond the state program or the state-run, federally provided for program. So that would be something to look at as well. I'm not comfortable making responding to his question directly. There's just not enough information. And even if he gave me the additional information, I'm not specifically familiar with. We do Inland Empire work, but it really is, even on the areas where we did stuff last week, we're at the place where we're checking every day whenever we have something new come in.
Yep. Makes sense. Gosh, it's complicated. So on the topic of relief funds, Michael, you mentioned this earlier, but I wanted to get a little clarity there. I know originally, like, the relief funds were only slated to be available for rent that was due basically through the eviction moratorium, but obviously they're still available right now. Is there a sunset date through which the relief funds are no longer available right now? Are you aware of that?
I don't know if Bruce has more information than I do on this. I know that Housing is Key, which is who's administering, is probably I think it's the biggest program in California. It's administering money that's coming directly from California, is my understanding. That one, they're going to go through March 2022. And I think the others are probably going to follow suit. I don't have any specific information about how long Long Beach is going to pay through. But Housing is Key is sort of setting the precedent for the rest of the programs, and I think March is the date. Bruce, do you have any more information on that?
I don't have any specific information. Previously, there were specific deadlines by which funds had to be committed, and deadlines for the date by which the funds had to be actually paid out. A lot of those deadlines have softened. The March 2022 date is one that I've heard in various contexts. Not sure if it applies to all of the issues that we're discussing at this point. The good news is, because other clients have had the same experience Michael has, that Long Beach has been the slowest to get up to speed and the slowest to process anything. One tidbit that Michael mentioned, that some files are being canceled or declined or denied because you have a landlord and a tenant that applied. I've had different clients who have dealt with interacting with the system in very different ways. One says, I get more mileage out of calling in, and if it goes to voicemail, I just call them back, and I can do more, including saying, hey, I just talked to my tenant. I see that they've applied. We already had a pending application, and they've had the ability to merge the two files, or to clean one up and move the documents over to the other one, and that sort of thing. Other clients have said they try to call, they get the voicemail, they send an email, they don't get a response to that either. So I think it's kind of a hit and miss, but it's persistence is what I think more than anything else is going to pay off. Don't give up easily.
Bruce, I've got a client who was frustrated with how long it was taking, and he said to my customer care delinquency department, give me the phone number, I'll call him. So he called them, and they had told us that they were still going through the approval process, and he called and he got to somebody at the top, and she said, oh, yours has already been approved. So he called my staff back, and my staff called and talked to somebody else who said, you're missing documents. And then he called again and spoke to somebody else who said that we were missing documents, but we have an email that said that all the documents are complete. I mean, this is a true story of a case where we have 3 or 4 different people telling us different things. And there was a time there where I heard that Long Beach was going to give the administration of these funds back to Housing is Key. And I was jumping for joy, but that went away, and it doesn't look like it's going to happen. But the administration has just been it's been
What a mess.
And the other day I saw a letter from Long Beach tooting their own horn about how great they've done in administering I mean, I hope there are no city officials here because I depend on Long Beach, but it's been very frustrating.
Well, actually, I think when you saw the improvement, as I understand it, the city of Long Beach actually subcontracted the work out to Yardi.
To a property management software company, yeah.
Right, they're the ones that are actually running the backbone of the system. So I think there's actually some employees from the housing that was running the Section 8 program that are participating on the Yardi site at this point. So I think they had a rough startup. They've transitioned over to Yardi. The feedback that I'm getting is that it has been improving, at least some.
That's good.
When the money starts coming in, I'll tell you the same thing.
Yeah, really. I'm sure I have some too.
Well, it is rolling in slowly, by the way, and I think it's ticking up a little bit, but there's still a lot out there that's due.
So that leads me thinking this through, right? The question is, when is this over? Like actually over? Because we thought it was over, and now we're here having this meeting because it's not over, and we need to figure out what is not over about it, right? And so, just conceptually, when the relief funds are gone and the funding doesn't get reallocated, is that it? I mean, at that point, is it truly business as usual? Is that kind of what we're led to believe at this point?
I think it's forever changed. I think some of the things that we've experienced in the context of this whole COVID mess, including the complexity of the processes that are going to be available to us, while they may be less complex moving forward, there's still going to be a sufficient level of complexity that it's not for the faint of heart. There are a number of attorneys that I know that used to practice in this area, just kind of like, frankly, just like some property managers that were real estate agents who said property management is easy. Anybody can do that. I'll pick up some easy money. I mean, I'm encouraging more and more of my clients to seriously consider hiring Michael or other qualified companies because they will do a better job at keeping up. And even as hard as we all try, it's hard to keep up.
I can't imagine doing it myself. There's no way. Yeah. I have the opposite opinion as a real estate broker in the market that property management is easy.
And if it ever was, it's not now.
Yeah. What a mess. Either of you guys aware of any like websites or lists that keeps it up to date? Restrictions by city type reference? That's a good question from Ray.
I've seen one, and I spent a little time on it, but I don't remember what it was. So obviously, I've only been there once.
I come across them at different points in time as well, and frankly, while you can certainly Google them, and I know that I think it was a mobile home association that actually had a fairly good list that was out there. We even had one internally in my office, and it just gets to the point that it is so challenging to keep up. The good news is there are fewer and fewer cities that are having their own ordinances.
Right.
And so that is one bit of good news. And I think that at some point that will probably pretty much drop off, with the exception of the LA County Board of Supervisors and of course LA City. Those are the guys who like to play that game.
Right.
Guys, I think it was on the California Association of Realtors website. I'm recalling now. I can't find it, but I think it was on the CAR website where you could pick the county and pick the city, and you can find some details.
Nice, thank you. So Michael, on a lot of doom and gloom here on evictions and getting people out and non-payment and stuff like that, but
it's not so bad. Right.
Let's talk about the reality here in the leasing market and the property management business. Like lay a little statistics on us from the Borba report. What's vacancy look like? What has rent growth look like? What does lease up look like? For tenants that are maybe actually planning on paying the rent.
Well, I'll start by saying that the balance that we have due from all our current residents is about 1/3 of 1 month's rent. We've been in COVID for what, 18 or 19 months now. And of course, we've had people leave, so this is not a perfect picture. But if you had a $1 million rent roll, for example, you have maybe $300,000 still due to you after 18 months. And so in terms of what has actually gone down, like I said, 10% of my residents owe $1,000 or more, and most of them are within $1,000 and $3,000 or $4,000. There's really a small fraction that owe between $5,000 and $25,000 or $30,000, and that's what makes up the vast majority of the total amount that is owed. In terms of how the market is doing, the rental market is incredibly tight. I was really surprised this year in August, because in August you could do an 8.6% rent increase because you had to use the April CPI figure to come up with the August increase. And I had so many clients that did the full 8.6%. Some of them didn't do increases during COVID, but their rents were near market because they were rented right before or during COVID. I thought we would have a lot more vacancy. Our vacancy rate actually right now is 2.8%. It's the same as it was at the end of last month, which is the lowest it's been since the beginning of COVID. Vacancy was very low in the beginning of COVID because nobody was moving, everybody was scared. We didn't know what COVID was. But basically, our vacancy rate right now is 2.9%. Today's the 28th. And I believe that the vacancy rate will be lower in just a few days because a lot of people are going to move in over the weekend. So the lowest vacancy rate I have at the end of the month on record is 2.5% last August. We're probably going to be 2.6, 2.7% now. In terms of leasing, our average leases per month is about 55. This month we had 43 leases so far. We're going to have a few more over the next few days. But that's misleading too. The reason I don't have a lot of leases is because I don't have a lot of units vacant to lease. And we've only got 40 units out of our entire portfolio are currently on 30-day notice. And this time of the year, I generally see more people leaving. I also see vacancy rates ticking up right now because we're heading into the holidays, and generally in the holidays, it's a little harder to lease units, but that's not the case. So rents are going up. The rental market is very strong, and right now we're making hay while the sun is shining. In terms of the rental market, it's going very well.
I can say anecdotally, well, and with some statistical evidence too, especially in the last 6 to 8 months, it seems like rental rates have just exploded, like market rents for stuff. We've put new units on the market in my portfolio that I was expecting to get $1,800 for, and they've gotten $2,100 or even $2,350. And I assume that's what's going on here, right? Is just that this incredibly low vacancy rate. There's nowhere to live. Same thing that we're seeing in the single family sales space, right?
Well, I can tell you, some of my property supervisors were still showing up with low numbers, and I thought, well, let's look at this. I think that doesn't make sense. So what we would do is, when we're using Rentometer or Zillow or some other tool, we're looking over the last 12 months. Well, when we changed, instead of looking back 12 months to looking back 3 months, many of these rental rates were up like 20%. And so that's an indication of just how fast rents are moving and how tight the rental market is right now.
Yeah, it's been crazy. Yeah, we've had to adjust all of our pro forma expectations on like every property we're looking at. And it's hard to believe the numbers I'm looking at, but I'm getting them.
Yeah, and some folks talk about. I think that vacancy will probably tick up just a little bit during the holidays because they always do.
Right.
And in terms of what I expect in July or August, some folks talk about residents moving out, owing money just before you can no longer get funds from the city or state. And it's not what I expect. I mean, we're going to have some more evictions, don't get me wrong, but there's so much more demand out there than there are evictions going on. All right. I just told you I have 15 going on for 2,500 units.
Right.
And demand for my vacant units surpasses that.
Very interesting. So, have you changed your screening and qualification standards now, knowing that there's that many protections in place for, picking a bad one, so to speak? What are you doing to try and nip that in the front end?
So we definitely have changed things just a little bit. Probably the biggest change we've made, we use a leasing matrix. We have category A, B, and C, and it's based on, how long you've been at your job and primarily your FICO score. And we're recommending to our clients that we don't even accept C residents right now, which is 550 to 610 FICO and all the other stuff that goes with it. Because we just don't need to, not even in some of the areas where traditionally that's all I could get. There's really no need for that because there's so much demand that why would you take a risk with a lower credit tenant? We've also found, remember, there are some protections for tenants who have unpaid rent because of COVID. You can't hold that against them when you are checking a tenant's history to rent to them. And so we find that the FICO score is really telling. And if you're going in the higher FICOs, like I said, in the B category, which is 610 to 670 for us, we're having a lot more success. We have a much better likelihood of hiring a good resident that's going to pay the rent for the long run. And, as I was going through the list today, Anthony, I thought it was really interesting that most of the properties that had really high balances were properties that came to me with residents or a property that hadn't had good tenant hiring practices in the past. And those properties were the ones that were most impacted. We're notoriously strict when it comes to renting to residents. And it pays dividends, especially through COVID. I believe it's paid dividends because the vast majority of those 260 residents that we have are residents that we inherited, and a small fraction of them are tenants that we rented to. So whether you have a management company or not, you've got to do a really good job checking backgrounds. Right now, especially with the tight rental market, be very strict. You don't. If you don't rent it today, you're probably going to rent it in next week, and you'd like to have a much higher credit tenant in there for the long haul.
Are you seeing income falsification and stuff like that?
Oh, we see that stuff all the time, but generally we see that in lower credit tenants, and so that's another issue that
right.
That we sort of is whisked away because we're looking at higher FICO scores and longer at your job and all those things that come along with a B matrix resident.
Yeah, good thoughts there. So Bruce, I know there were some rent freezes in place for a while in some of these jurisdictions too. Is that still going on, or if those expired, can we raise rents within AB 1482 rules, or what's going on there?
Well, 1482 is, I believe it's LA City still has a rent on a rent freeze. I think LA County does as well. Those are, I think, most of the areas that you're dealing with. Other than that, I don't think that, at least not in the Southern California area, I'm not aware of any other rent freezes. Michael, have you had any experience elsewhere?
Yeah, well, I have that property in unincorporated LA County, and I think I have to wait until January.
Right.
LA City, I think it might be beyond that, Bruce, but I'm.
Well, it is beyond that. Yeah, LA City is like, it's either 6 or 12 months after the declaration of the emergency goes away. LA County actually expires at the end currently, for now, until they change it. Expires at the end of January.
And the emergency order, has that technically been lifted?
No.
Right. So if it's lifted on December 31st, then we can't do a rent increase till January 2023 in the city of LA.
Yep.
Wow. Yeah, cash for keys, right?
Right.
Or strong in place rents.
Michael, question for you, Michael. The people that are doing cash for keys, are they people that are moving out of area? Because frankly, most of the people that are on the tenant side on the cash for key situation, they're going to be hard pressed to find, because of the tightness of the market. They're going to know where to go. So unless they're going significantly out of the Southern California area and still staying in California, or just getting out of the state, it would seem to me that it's hard to make a deal because they can't find a better option.
Yeah, well, I don't know the answer to that. I don't know where they're going. If I'm able to strike a deal, I'm not terribly, and I'm not the one striking the deal anyway. So
Right.
it might be something I'll ask my staff. We might even be able to encourage people to to move away because it's so much cheaper to live in other areas. I expect that that a lot of them are combining households. I mean, if they've fallen on hard times anyways, then they might be moving into a 2-bedroom rather than a 1-bedroom, and they might be moving in with somebody to save some money, moving back with family. I don't know the answer for sure.
Yeah, I think some of that going on. All right. I'm going to ask the final question, and then I see we have some questions in the chat. So, all the guests, feel free to enter your questions as we're talking about this last one here, and we'll get them all answered. And then we'll have a little networking afterwards as well in the Kumo Space app. So, let's talk about the future a little bit. We touched on this earlier, and Bruce said some interesting things. Where's this all going on a longer term basis? What's coming in the future for the landlord tenant relationship here in Southern California? Is this, some form of just getting used to more control from the government going to be regular? I mean, what are we left to think is going to be going on moving forward? Maybe I'll give that to Bruce to start.
Well, I think the direction of the legislature is pretty clear. I mean, they took advantage of the COVID experience and jamming through and claiming that we had emergency legislation that was required. They were gutting and amending a bill and calling it a budgeted bill to make it effective immediately. I mean, we were getting bills that were gutted and amended on a Friday morning and went to a vote on a Monday and were signed into law on Tuesday.
Yeah.
So they're just out of control. There's no signs of that changing. I think that is the generalized direction of things, unless there is an uprising that has impact. And I don't see it changing until it gets so bad that the people will finally wake up and recognize it's not the way to go. I think that more than any, I've been pounding the drum for some time, and I know this is the way Michael and his people manage their properties. Maintaining a good business relationship with your tenants, I think, is more important than ever, because I think the reality of what we've gone through, good landlords and decent tenants would have navigated through the system a whole lot more effectively without the freebies being dangled and that sort of thing. And I think those clients of mine who had good, personal leading but still business relationships with their tenants were the ones that fared the best through this whole process. And I think that is become more important than ever. And that's the one thing I think that you can do to buffer yourselves. Like I said, you don't want to be that guy. And
yeah,
that goes a long way.
Great advice. Michael, what do you think?
I think it's interesting Bruce brings that up because we're finding that tenant retention programs are just as important as employee retention programs right now. Everybody knows it's hard to find good employees, so we're working on employee retention. I think tenant retention is important as well, so we're thinking of what things we can do to
we lost it.
To make it interesting, to keep our residents around. I mean, we've always had a good relationship with our residents, and I talked about that a lot at the beginning of COVID. The reason why our people pick up the phone, our residents pick up the phone for the most part, is because we're not yelling at them. We're trying to work with them. We're asking about their situation and seeing if we can make payment arrangements and that sort of thing. So no doubt about it. And I think moving forward, it's going to be even more valuable because you want good tenants that are going to take good care of your property, pay market rents. And the most expensive thing that a property owner deals with is a vacancy. So if as a manager we can eliminate that vacancy altogether, then I think it's going to be better for everybody. And in terms of what's changing, I don't know. I feel a little different than Bruce because I think that a lot of politicians own real estate too. And so kind of my sense is that, there are loopholes built in here and there. Number one. Number two, we just have to be a little bit smarter about the decisions that we make on real estate, because there are still ways to make good investments and add value, like building ADUs, et cetera. And I think that that as long as you're studying what the best thing you could do now is, then we'll be all right. And when you're buying a property, if you underwrite it properly, then you're going to be in pretty good shape.
Nice, thank you. Well, Bruce lost his connection, it looks like, but let's go ahead and take some questions. Hey, Stephen, how's it going?
He just said he lost his internet. Let's see.
Okay, well, we'll wait for him to, while he's trying to log back on, we'll take Stephen's question. He's looking at buying a building in Long Beach that has a non-paying tenant, and the seller has applied for funds on behalf of the tenant. If I were to purchase the building, what would be the best path forward? Would I need to apply for funds assuming tenant continues to not pay, or can I piggyback on the existing application?
We've taken over some properties where the application was transferred to us. Now, there's an issue of whether that rent should go to the seller or to the buyer, and that's something that you would work with your real estate agent on. And Anthony was talking about it earlier, if if those funds from the past should be assigned to the buyer or to the seller. So the answer is I'm not exactly sure, although I have seen applications transferred to the buyer. It's probably something that you'd have to work out with the agents, but also with calling the caseworker. So each application, a caseworker is assigned. Unfortunately, sometimes you get different answers. I gave you an example earlier, but if you call the caseworker that's assigned to that particular case and ask this question, and maybe call again and make sure somebody else gives you the same answer, then I think you'll get what you're looking for.
And you can, I think we mentioned this previously, but maybe not tonight. You can apply multiple times, right? Like if you get paid for a certain covered period and then the tenant continues not to pay, can you apply again, after ownership is transferred?
Yes, you can for a new period, no doubt about it.
Nice. Yeah. JP, I think Bruce rejoined us if you want to pin him again. Cool. Hopefully that answers your question, Stephen. Any other questions from the audience? Feel free to unmute or throw them into the chat. This has been an enlightening discussion for me. I'm in this every day and I still lose track of the rules. It's so confusing. So we have to do these meetings regularly so we can keep track of what is going on, right?
Anthony, I'd say from a management perspective, I'm in it just a little more than you, and I have to try to keep up every day with what's going on and changing. It's crazy.
Yeah. He's back. Welcome. He's muted.
You might have to unmute him, Joseph.
Okay, I think we're back in. Sorry about that. My Zoom got unhappy.
All good. Well, maybe while we're waiting for some other questions to come in, if there are any, Bruce, do you want to give everyone your contact information? Maybe throw your website, email into the chat. What's the best way for people to reach out if they need your expertise?
Just call Michael. He has all my contact information. No, it's menkylaw.com. It's a very old website, but it still has all the contact information. And it's evict@menkylaw.com is our generic eviction email. So those are probably the easiest ways to connect with us.
Awesome. And Michael, how about you?
So I'm going to go ahead and put, oh, there it is. I'm going to put it in the chat for Bruce and for me as well. But I'll put my email there and phone number there. And like I said, I'm happy to help anybody if they've got any questions.
Awesome.
That was nicely done, Michael. Under the guise of being helpful, you just dodged all those phone calls I was sending your way.
And Bruce, Paul has a good question here for rent increases in LA. If a tenant has been paying rent all along, does the rent freeze apply, or are we allowed to raise rent?
If it's an RSO property, it's an RSO property into the rent freeze.
Total rent freeze.
Yeah.
Bummer.
There's no need to qualify for the benefit.
For that. Got it. Okay. Hi, Chi. Yes, a quick yes or no question. Did you say that the rent freeze in Los Angeles won't be lifted until January of 2023?
We don't know when it's going to be lifted is the answer. That was Michael's hypothetical, and we don't know. We just don't know at this point.
It's from a year, just to recap, the answer is complicated, but it's from a year after the expiration of the state of emergency. Is that right?
Michael, help me out. I think it is a year.
Yeah, I think it's a year, and and that has not expired yet. So I was just hypothetically saying if it expired on January 1st or December 31st, then it would not be. You can do an increase till January 2020.
Yeah, if it expires that soon, it'll be
right.
And then it'll still be a year, right? And that's just up to Garcetti.
Right.
Yeah.
Yep.
A whole 3%, anyways. But
rough. So the right answer, of course, is under extreme constraints of supply, is go build some stuff, right? If only that were easy.
That's where the government hasn't figured it out, and they keep blaming the landlords and the builders for not building when they would be happy to build, but they're just not able to in the political environment and the expense involved. It's a quagmire.
Yep.
Well, Anthony, what do you see in property values in RSO? I mean, is now the time to sell your RSO properties and move into something else if you're gonna have to deal with this for a year anyway?
I mean, it's a long wait. They're still going. They're selling. There's lots of volume all over LA City. Highly sensitive to actual rents is what I'm seeing. And it's a game of cash for keys. So for people, we get clients that are looking to buy apartments in LA, and they want to do a value add deal. And the first thing to talk about is, okay, let's talk about your budget, because if you want to do a value add deal in the city of Los Angeles, you've got to budget 20,000 plus per unit in a lot of cases to do cash for keys. Rent stabilization ordinance. Thank you, Jeff. The jargon is flying. But it's a lot easier, even in some of these other restrictions that we have in place in Long Beach and elsewhere, it's still a lot easier. But the properties that have strong actual income are going, and they're expensive because, like you said, Michael, when there's now almost 3 owners that go through the life cycle of a building from tired with a lot of deferred maintenance and low rents to at market. There's the old owner manager that has the building that's owned for a long time with low rents that sells. Then there's a person that comes in a lot of times and will buy the building with the specific strategy of buying the tenants out and doing basically nothing else. And I frequently see properties sell half vacant. They'll get as many tenants out as they can. They'll get the low hanging fruit, whoever agrees. They'll relist the property 50% vacant or sometimes even more. The property goes for substantially more money with the vacancies in place. And then you get a third owner that comes in, does really nice renovations, and takes advantage of that extreme supply and demand disequilibrium we have going on. And the rents that you're getting up in LA make Long Beach look cheap. So it's a weird market. It is still working, but you really have to know the rules. You've got to be really comfortable with the uncertainty. I would be careful on the financing getting into those deals, because there's no guarantee that you're going to be able to execute on your, increase in NOI at all during the period of a short-term loan. So, but the weird thing is that the values are higher up there than they are in some of the other areas. And I think really because of the lack of sales and inventory and rentals, it just pushes everything higher.
And Anthony, even at $20,000 to $25,000, you can't force the tenant to move out in RSO, right?
They don't have to say yes. They could say no to $100,000.
Yeah.
They probably won't. But at that point, and it could pencil at $100,000 actually, which is the crazy thing. Yeah. But you got to have the cash to do that, obviously.
I actually had a client who's owns about 3,000 units, and he's making so much money over the last number of years, and he started doing bridge loans. They were actually doing a bridge loan for a guy doing a deal in Santa Monica, and the purpose of the money that he was raising was to pay like $200,000 per unit to be able to do cash for keys.
I am not surprised. That is the reality. It's just wild. Great question, though. I saw one here. Let's see, from Roshan. How much can you raise your rents in California? Right now, currently, the general state AB 1482 amount allowed is 8.6% in a rolling 12 months. That's based on April to April CPI numbers ending in April of 2021. And so that we'll get new numbers on that probably in May or June of 2022, right, Michael?
Yes, but you said, but he asked California, so you have to go and check. You have to go check the CPI for your market,
for your region.
Yeah, for your region, it's a little bit more in San Diego and a little bit less in other places. So I believe it's the April CPI that comes out in May. That's what you use for increases that can be effective on August 1st.
CPI is change in consumer price index. It's a measure of inflation. And it's interesting right now because we've got inflation back in the market for the first time in many decades, right? With all of the price increases and the supply chain mess we have going on. So we started seeing the impact of that already. Last year, the allowable increase in our region was 5.7% because the change in CPI was only 0.7. So it's 5% plus the change in CPI. This year it's 8.6%. I think next year we've got a good shot at 10, right? Because we were looking at annual CPI numbers in the 5s already right now. So if it doesn't calm back down, you may get a 10% number. And Michael, I saw just put the source in there from the BLS, and I believe our region is the Los Angeles, Long Beach, Anaheim region. Is that right?
4.6 right now.
4.6. So that would be, if they were cut it today, it would be 9.6% allowable increase in our area, which is pretty good.
Yeah,
it's very good. And Stephen has another good question. So for Long Beach, is he currently prohibited from evicting a tenant if he wants to own or occupy the owner's unit?
The answer is no if you ignore the LA County or Tenant Protections Ordinance. If the LA County Protections Ordinance applies to Long Beach, the answer is there is a restriction.
So it's up to the judge.
Right. And we have yet to find a judge who has acted favorably. The judge we have next week is one up in Inglewood. And of the judges that we've dealt with, he's probably our best shot. But I can also say that we have a judge in Long Beach that we dealt with recently that I thought was going to be that guy. It turned out that he wasn't.
Bummer. So I guess there's Stephen, you can give the increase under the assumption that you are going with city law and see what happens, right? If the tenant goes and hires an attorney and they take you then to court, then you're at the whim of the judge. Good question here from Tony. For RSO properties, are you able to implement RUBS? And for those that don't know, Michael, can you explain RUBS?
Ratio utility billing system. It's where you get the bill and you divide it up amongst all tenants that are by contract allowed to pay RUBS, and it's based on square footage and number of occupants in the unit. So anyways, you're splitting up a trash or a water bill based on occupancy.
And is that allowable in LA rent stabilization ordinance properties?
Bruce, can you answer that? I stay away from RSO.
There's an issue that about RUBS in particular, and my understanding of the law, and I have looked at it recently, is that I'm working from memory, so don't hold me to this. If you didn't have a RUBS system in place as of, I believe it was January 1, 2019, the code provision indicates that you are not able to implement it now, which is kind of silly if you think about it. I mean, the whole impact of RUBS is the user pays. And so we all know that if you're the guy paying for it, you're going to be conserving, whether it be water or whatever else it might be. So that's my understanding. I hesitate to give a clear-cut black and white answer, but that's my general understanding.
We are still implementing RUBS. We have clients asking us to implement RUBS, and we're doing it. The risk is that if they showed up to court and it was determined that I was not allowed to implement RUBS, then any amount they paid for RUBS would apply to rent and would have overstated the 3-day notice or whatever notice I gave them. So, the risk is not huge, but I still have clients asking me to do RUBS. In terms of, is RUBS allowed in RSO? I'm sure that you can't implement RUBS today because it would be considered a rent increase. And my guess is if you were going to implement RUBS at some point, then you'd have to, I've heard somebody at Bruce's office say this before, you'd have to take the last 12 months of expenses and determine what 3% looks like it would be, because you can't just, it's the equivalent of giving somebody a rent increase.
Right.
But for a new resident, I don't know if you can do it at RSO. Maybe not. Bruce is saying that he's read rules that say you can't do it at all.
You would think the lease would control, but yeah, maybe if they're just saying you can't do it, you can't do it. Great questions, everyone. Okay, so do we have some more? Maybe not. Thank you for giving us your time, Michael, Bruce, consummate experts on the subject. I always love talking to you guys about these things. Very helpful for everybody here, and we really appreciate it. When is the next show? We'll see. Maybe when the relief funds run out, we'll be back here doing a follow-up so we can figure out what's going to happen next. Great question. JP, can you throw the link in for the Kumo space in the chat? There it is. So for those of you who'd like to join the networking, this is optional, of course. This is a fun little app where you can walk around a virtual room and just talk a little bit with people that are near you. If you haven't tried it, it's kind of cool. It does get a little wonky on mobile, but feel free to try. And from my understanding, if you are still in the Zoom meeting, it gets very confused with video and audio. So I recommend copying the link. We'll leave it up for a little while here, put it into your browser, save it there, and then after us windbags are done adjourning for the night, and leave the Zoom meeting and then come back in. So thank you everyone for joining us. Thanks, Ray, for the suggestion on a future topic. Maybe we will do that. And of course, Bruce and Michael, for your time. It was excellent having you.
Thank you. Thank you, Bruce. I always learn so much from you. I appreciate you.
Thank you, Michael. Same to you.
All right, we'll see everybody next time.